Morning. Thank you for joining us. Today we have Angela Lozada from the Lozada Law Firm in Las Vegas, and she will be talking to those of you who have filed your own bankruptcy and would like to know what to expect at a 341 meeting of creditors.
Thank you. Hello, everyone. I'm going to start our PowerPoint. Okay. So today we're going to discuss what to expect at your 341 meeting of creditors. So as most people are aware, your 341 meeting of creditors is something that you are going to have to attend, and it's usually about 30 days after you file your bankruptcy. So first and foremost, what is a 341 meeting? The 341 meeting is also known as the meeting of creditors, and it is a requirement in your bankruptcy process. The 341 is conducted by a trustee. So every case when you file is assigned to a trustee, and that person's role is to make sure that the interest of the creditors is protected, especially since the creditors are most likely going to be losing something as a result of the bankruptcy. So the 341 meeting is used to ensure that the information contained in your petitions, forms, and schedules is all accurate, and to inquire as to any additional information that the trustee may need from you after reviewing your documents. When you go to a 341 meeting, you are sworn in by the trustee. And when you are being sworn in by the trustee in this case, it is under the federal bankruptcy court, which means that your oath is protecting your testimony in a federal proceeding. What that means is if you intentionally provide any false or misleading information, it can be considered and prosecuted as a federal crime. So you just need to make sure to be careful to be giving truthful and accurate information to the trustee. The first thing that you really need to do is to make sure you're prepared for the 341 meeting. Understanding what's going to happen in the 341 meeting doesn't work if you're not prepared for it. So the first thing that you need to do is you need to prepare all the documents that were filed in your case, especially if you had anybody help or prepare those documents for you. You need to be very familiar with what's in those documents. So just make sure to know what assets you have listed, what debts you have listed, what you're looking to retain, surrender, the exemptions you've applied, all of those things. If you find anything inaccurate in your documents or something has changed, you can simply amend your pleadings. There's no limit to the amount of times you can amend your pleadings, and there's no charge for amending your pleadings. So it's definitely good that if you notice anything incorrect, go ahead and amend your pleadings so that when you're sitting there in front of the trustee, they see that you've already corrected some of that information. Additionally, when you file the bankruptcy, you will receive a notice of the bankruptcy that includes information about your meeting of creditors, including where the meeting is going to be, which right now most likely is going to give you a link for a Zoom meeting and a password. Other times it would tell you the physical address and room number. Also included with that document is a bankruptcy information sheet. Make sure that you review that form and note any questions that you may have with that form. In addition to just preparing what you've already filed with the court for your 341, you also will need to provide documents to the trustee that is assigned to your case. The documents that need to be produced are very similar in most cases, with a few exceptions if you have certain types of income or assets. You need to provide those documents as soon as you can to the trustee, but no later than 7 days prior to your scheduled date. If you do not provide the proper documents to the trustee, they're very likely to continue your meeting, which is just going to extend the time of your process. So what documents do you need to provide for the trustee to review to prepare for the 341 meeting? First and foremost is you will receive a trustee's questionnaire. This questionnaire is very short. It's primarily just some yes and no questions with a couple fill in the blanks, such as if you purchased a home, what year, and information such as that. But for the most part, it's information you've already put in your petitions, but maybe just a little more specific. For instance, on the petitions, it will ask if you've paid any payments over a certain amount during a certain period, but on the trustees questionnaire, it is a shorter time frame and bigger amount of payment that is asking about verifying. Next, you will need to make sure that you provide your driver's license and social security card to the trustee. They must have something with your social security number on it to look and compare it with your petitions, make sure that you are who you say you are. And then of course, your driver's license, they will use to identify you through the video or in person as who you are stating you are. You will need to provide 6 months of bank statements, and those 6 months go through the date that you filed your bankruptcy. For instance, if you filed your bankruptcy on December 31st, you will need to provide from June 30th all the way through December 31st to get that full 6 months of time frame. You will also produce any statements, your most recent statement from your retirement accounts. Usually it's best if you get monthly statements. Go ahead and do the same 6 month statements for that as you would do for your bank statements. You will need to provide tax returns. The amount of tax returns that you need to provide is actually different depending on the type of bankruptcy you filed. If you filed a Chapter 7, you only need to do your last 2 tax returns, where if you file for a Chapter 13, you will need to provide your last 4 tax returns. Also be aware that many people filing bankruptcy are either on Social Security or very low incomes. If you do not file a tax return, you are not penalized for not filing it, but you will notify the trustee that based on your income, you are not required to file a tax return. Additional documents you need to provide is proof of your income. So when you file the bankruptcy, your income is the last 6 months. So again, if we're using the same timeline, just to make things easier, if you filed December 31st, you need to show proof of your income from June 30th through December 31st. If you work a normal W-2 job, you would just simply provide your pay stubs. If you are just on Social Security, you will provide your Social Security award letter that you received the most recent year. If you have pension or retirement as your income, not as future investments, you're actually receiving it, you again would provide your annual letter showing what you are receiving, which can again be at that point verified by looking at your bank statements and what's being deposited. If you own a business or are a sole proprietor, you would need to provide the court with 6 months worth of a profit and loss statement. There's many ways to find out what needs to be in a profit and loss statement, but that is one way of verifying your income as well. There are also a lot of people working 1099 jobs these days that do not provide them bank statements, such as Uber. So if you do not receive an actual pay stub, you can still use your bank statements for the court to see and the trustee to see exactly what is being deposited into your account over those past 6 months. So your bank statements in this situation would actually work to verify both types of information, both your income and just for the trustee to review your financial transactions. So now you're prepared, you've submitted all your documents to the trustee, you've reviewed everything to get ready to go to the 341 meeting. So at that point, what to expect. So the first is who is actually going to be present for your meeting. Most of the time, it's just going to be the trustee and the debtor or debtors. There will be 2 debtors if there is a married couple filing together. There's a possibility for other people to be present. Creditors have a right to show up to the meetings if they have specific questions regarding your assets, your income, your debt, or maybe the disposal of any property that secured their debt. It's rare that a creditor is going to appear for this, but it is possible. So don't be frightened if there is a creditor that shows up to ask you a couple questions. Additionally, If anything in your papers is concerning and raises any red flags, then the U.S. Trustee's Office will have a representative present for the 341 meeting. And after the trustee finishes any questions, then the U.S. Trustee's Office will be able to ask you questions as well. It's not often the U.S. Trustee's Office is involved, and it's usually only if something in your paper signifies to them that there might be fraudulent or misleading information, and they're going to make sure to confirm and verify that information. And again, the trustee is going to administer the oath prior to actually asking any questions. So after you get sworn in, the trustee is going to take and look at your identification and social security card. Right now by Zoom, you would have already sent that to them. If we're not doing it by Zoom and they are back in person doing the meetings, you would hand both your ID and social security card to the trustee, who would at that point verify your social security card matches the social security number on your pleadings, and would check your identification and picture ID just to verify the person appearing before them is the same name as the person who's on the petition and on the social security card. They will also verify your address that is on your ID and whether or not that is still an accurate address from you. If it is not, the trustee will simply ask you to update the information on your forms and pleadings. The trustee will very often ask for a phone number to place on their records. This is something they do whether you represent yourself or are represented by counsel. Again, they're verifying information and making sure there's contact information for you on file. The trustee will ask the debtor, did you review the petition forms and schedules prior to signing the documents? This should be yes. You need to make sure that you are very aware of what's in those documents as you are signing under penalty of perjury, that the information is correct, and you can't do so if you haven't reviewed the information. The trustee is going to ask you, did you include all assets and all debts in your forms and schedules? If you are married and your spouse is not filing with you, the trustee is going to verify that all of your spouse's assets and debts are listed in there as well as income, because we are a community property state, and whether they file with you or not, that is considered an asset, debt, or income to you personally as well. The trustee will also confirm that the information is true, accurate, and complete. So in addition to asking you if you've listed everything, they're going to ask if all that information is accurate. If you found something that is not accurate, it's okay, speak up. Don't hide it. Just let the trustee know, I found an error on whichever form, and you'll simply file an amendment thereafter. Additionally, the trustee will have already reviewed all of the documents that you have produced to them prior to the 341 meeting. So they will go through your bank statements and look at all of the transactions. They'll look at all of your pay stubs. They'll look at all of those documents. If there's anything in there that they have questions about, they will ask you to confirm. So if they see a large deposit that didn't become from income, or if they see a very large withdrawal, they're going to want to know what you did with those funds, especially if it looks like those funds should have been used to satisfy debts to creditors. So the trustee may have specific questions. They may also have questions regarding assets. If you have multiple vehicles and only exempted one, the trustee may have questions about the year, make, model, condition of other vehicles to know whether or not there's a value for the trustee to have for the estate. If you have a timeshare, they might ask for the supporting documents, especially if you're not wanting to keep it, to see whether or not there's any possibility of the trustee getting a value for the estate for the creditors. A question that throws a lot of people off is the trustee is almost always going to ask, so what made you file bankruptcy? Especially if it looks like there's not a change in your employment or anything along those lines. They want to know what it was that made you file bankruptcy. It's not a trick question. Don't be scared, not unless you are doing something you shouldn't be doing. People simply will state, I got behind on my credit cards, or I fell behind on payments, once I got behind, or I had a loss of income. Any of those are perfectly acceptable. The trustee is going to understand that. They just need to verify what happens that is different that made you need to file the bankruptcy. As I stated before, if after asking all of these questions, the trustee has any concerns about the information, or specifically, if there's anything that you state to the trustee that is not in line with what's in your forms, the trustee is going to tell you that you need to amend your forms. And just a side note is that I've caught many unrepresented individuals being confused when the trustee starts telling them to amend their SOFA and then spits out a number. SOFA is just an abbreviation, a short term that the trustee and bankruptcy attorneys use. That is actually your statement of financial affairs. So if you're in there and the trustee tells you to go edit your SOFA, that's the document that the trustee is talking about. Additionally, the trustee may ask you to provide additional documents. So again, when we talk about some of those assets or incomes, the trustee may ask you to produce something specific. A big area where the trustees often have to ask for additional documentation is on bank statements. For one, some people are confused about the time frame and the specific dates that the trustee may need. So maybe they don't provide something because it's just right outside of where they thought it needed to be. The other thing is that banks do not work on our trustees' timeline. So it's very possible that if you filed your bankruptcy on December 31st, your bank statements might actually go from December 21st or 22nd, somewhere in there, to sometime mid-January. What that means is you might have the statement from the beginning of December, but even by the time you go to your 341, your bank may not have issued a new statement. Again, not a huge ordeal, especially if the bankruptcy trustee is already happy with all the information you provided and all your other bank statements. They're usually just going to tell you to go ahead and provide that last bank statement as soon as possible so that they can conclude the meeting. Additionally, the trustee may choose to continue your meeting. So if there's multiple things that need to be done on the case, especially you need to amend pleadings and forms, you need to produce new documents, or specifically if there's documents the trustee has not seen and they think reviewing it might cause them to need to ask additional questions, then they're going to continue your meeting. That just simply means you will come back at a later date to answer any questions they have. However, if the information that you produce to the trustee, they review it, they have no further questions, they'll usually go ahead and just conclude your meeting and you do not have to come back. So in general, that's how the meetings go from start to finish. I am going to throw in just a little more information before I start taking questions. Some of the information that people need to make sure that they're putting on their petitions, because it waves flags to the trustee and is going to make them ask you questions, is make sure you specifically identify your assets. A lot of people will not list that they even own clothing or jewelry or, furnishings, appliances. If you have them, you don't have to be super specific. We don't need VIN numbers, but if you put something such as everyday clothing, that at least shows the trustee that you are in fact showing what your assets are. And also, if you do not list one of your assets, it cannot be exempted, which means protected, and the trustee can't take it. So just make sure, because I have seen trustees make comments to debtors, usually in joke form, but they'll make jokes such as, "Oh my God, thank God, I thought you were going to be naked. You said you don't own any clothes." So just make sure that you check your forms and make sure that under your schedules, when you're listing your assets, that you do in fact list, even if it's a vague description of, I have a living room set, a dining room table, 2 beds and a couch, is still showing the trustee what you have as opposed to saying nothing. Check and see if I see any questions. We'll give just a couple more minutes and see if anybody has any questions. Once you get to the 341 process, it can be very scary, but as long as you're prepared, it should be pretty simple. I tried to give a lot of my tips that I give my clients. It's better to overshare with the trustee, right? It's better to make sure that under electronics, you tell them, hey, I have a cell phone, than it is for you to go in front of the trustee and they don't trust whether you've provided them accurate information. The more information you provide them earlier, the less questions they'll have and the faster your 341 meeting will go, and the more likely it will be concluded without you needing to provide anything else or to come back at a later date. All right, so it doesn't look like anybody has any questions. So good luck with your bankruptcy going forward.
Thank you so much, Angela.